Welcome to iEnhance Advocate. iEnhance Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Janak Padia. He is going to speak on global perspective, reality and legality of call recording. So without wasting further time, I would request Janak to commence with his lecture. Thank you.
Good morning to one and all. So this is Advocate Janak Jiten Padia and my topic is global perspective of call recording, its reality and legality in the current world. So nowadays, being in the digital era, often people use mobile phones for their daily works, and there is a feature with the upcoming mobile phone that is call recording. And in this digital world, people often are having their businesses over phone calls, either via voice calls or via video calling. And the feature which we are talking about today is call recording, which helps the people to record their conversations. So it is a thing that later on, when if there are any crisis in the business deals or any situation for which the call is being recorded, the person who would move away from his word would not have any option, because there is a call recording which would amount to a proof for the things which has been said by each of the parties in the calls. And such call recordings are becoming more frequent and more often, wherein the people in their day-to-day life, either within the families or within their business deals, they are using such call recordings to make a safer side for them. And I would say it is not a bad thing to record a call, but like we say, there are pros and cons for everything. So there have been some legal developments in India and even globally, which would allow call recording also legally, and even which would some countries or in the world say that call recording is not legally valid. Say that call recording is an electronic form of recording, and after the IT Act, which has came in 2000 year, which was effective from 1710-2000, there have been developments in the definitions of electronic forms, electronic records, and also which has led to development in the Evidence Act. So the section 2R of the Information Technology Act 2000 says that electronic form would amount to an information which is generated via an electronic medium, either sent, received, recorded, or stored in any media tools or a CD or a mobile phone amounting to a electronic device. And section 2T, which talks about electronic record. So it says that data record or generated or image or sound stored, received or sent via an electronic medium or electronic form would amount to an evidence in electronic form. So also the Supreme Court has laid down the similar things in K.K. Swami case, where it says that an data stored in an electronic form or a call recording which is stored either in a mobile phone or in a pen drive, or we can say in a CD, anything which is amount to an electronic device, such would fall under the section 3 of the Evidence Act, read with section 2T of the Information Technology Act, which has led to the development that section 3 of the Evidence Act now also includes the evidence in electronic forms, which is also counted under a documentary evidence. Modernization in the technology has led to call recordings being increased in frequency, and which has called a clash between the constitutional right of person, which is right to privacy. Since when we record a call without the person on the other side of the call knowing that his call is being recorded, it would amount to a breach of his privacy, because he would be talking or he would be having a conversation with the other person thinking that this is only between the two, and in future no one would know about the things spoken between them unless and until either the person on the opposite side says to it, but there would be no proof whether the person who is saying is true or false. But when a call is being recorded, it would be making a proof of the things, that these things were spoken on this date, this time, between these two peoples. And similarly, the right to privacy, which is a constitutional right under Article 21 of the Constitution, it leads to breach of this article where people would record a call for harming the person on the other side. It was held by the court in People's Union of Civil Liberties versus Union of India in 2003 that recording a phone call without either the consent of the person would amount to a breach of his right to privacy. But there are always some exceptions with this. It would be the section 5 subsection 2 of the Indian Telegraph Act, which gives the right to the government with some exceptions to record a call or intercept a call between two parties, which says that either it is for the safety of the entire country and the people, or for some emergencies which, if not recorded, would harm the country and its people. The government says that recording, tapping, or intercepting calls of the people, this falls within the exceptional realms of the Article 19 and 21 of the Constitution. But the scenario on the other side is very different when it comes to recording of a calls via a non-governmental organization or a regular citizen, because in Indian laws there is no specific laws which says that call recording is legally invalid or is not allowed or should not be recorded. But since it amounts to the breach of privacy, there are civil remedies for the people when their call is being recorded without their consent. We often, when we get calls from a telemarketing company, or often we call to a customer care of any person for any of our issues, they often give a warning to the people that this call is being recorded for quality purposes. This is done with reference to the Indian laws which don't allow recording legally, but there are loopholes within all of the laws. So to be on a safer side, there is always a warning issued by such customer cares or call companies. We often see when we go to a mall or a restaurant or any place where there are CCTV cameras laid for the security. Often there is a warning with such cameras that you are under a CCTV surveillance, so that people would later on won't claim that they were not aware that they are being recorded or there is some violation of their rights. But section 25 of the Indian Telegraph Act, which says that when there is a call conversation going on within two persons, a third party who is not a party to the conversation, who is not involved in the conversation, should not be recording or should not be intercepting or should by any of the way should not hear the call between such two peoples, because it would lead him to a punishment for 3 years fine or both. It was held by the court in the case of Rayala, Bhuvaneshwari versus Nagamendra Rayala, that Section 25 of the Indian Telegraph Act was specifically premised for this Article 21 of the Constitution, which guarantees the right to privacy. And the court in this case laid down that right to have an uninterrupted telephone conversation is very important right for a person, and it should not be breached by anyone. And it also asserted upon the point of right to privacy, which is guaranteed to the people of India, to every citizen of the country. Section 25 of the Telegraph Act, which says that, which includes a specific word, any person. So any person would amount to any of the person who is not the party to the conversation. Only the people between the two people whom the call is recorded are not any person, which implies that recording calls of a third party, recording calls by a third party is not allowed under this section. Beginning with the part of admissibility of such call recordings in India. Apart from Section 25 of the Indian Telegraph Act, there are no specific sections either on the criminal side which denies or which say that call recordings are illegal. But like it is said that when a call is being recorded, the right of privacy is being breached of the person. So he now has a civil remedy to move before a court for his violation of right to privacy. But since there not being any law on criminal side, it becomes difficult for a person to criminally bound the person, but he has the option for the civil remedies under breach of right to privacy. There are three parts for admissibility. First, relevancy of the recording. Second is authenticity, and third is compliance with the legal requirements. So relevancy of the call recording amounts to how much of the call recording is relevant to the case before the court. Authenticity refers that it has not been tempered or altered, or there has not been any manipulation in such recordings, and it is in its original form, like it was a regular conversation between that two people. And compliance with legal requirements, also being an electronic evidence under the Indian Evidence Act, there are some basic legal requirements which are to be fulfilled before an electronic document or electronic record or any electronic evidence is being accepted by the court as an evidence. One of such requirement is a certificate under Section 65B of the Indian Evidence Act, which states that person who is tendering before the court such evidence should provide a certificate either by the person who has recorded the call or who has transferred the call in some electronic form in which it is being produced before the court for its authenticity, genuinity, that there has been no tempering or no manipulation in such recording, and it is presented in the original form as it was, and also mentioning the details about the device or the medium through which it was recorded. It was in the case of S. Pratap Singh was the state of Punjab in the year 1964, wherein the court in the beginning held that a call recording, even if it was recorded illegally without the consent of the parties, but the court allowed such recording to be admitted in the case because only on the ground, only on the footing that such recording has helped the court to come to the conclusion of the case. it being a very vital or important evidence which helped the court to solve the case of the S. Pratap. And only on this ground it was allowed, since the development in the Information Technology Act and Evidence Act came on a later stage. But even at that time, the court allowed such electronic evidence, such call recordings, because it helped the court to come to the conclusion of the case. After the developments in year 1973, it was laid down in the case of R.M. Malkhani was the state of Maharashtra. The court laid down few parameters upon which the court would accept such call recordings or such tape recordings or such calls intercepted which are recorded. The three parameters were that, firstly, the conversation should be relevant to the fact of the case and to the case. Secondly, the identification of voice. The person between whom the call is being recorded, their voice should be clear, their voice should be identified upon hearing such call recordings by the court. Thirdly, accuracy of the call recording. By accuracy, we mean that the person who is tendering such call recording or electronic recorded evidence should eliminate the possibility of any manipulation or erasing or any addition or subtraction to such document or to such electronic recording. And these three parameters have formed an important footing for the future cases which have been decided by the Supreme Court, and Supreme Court, referring to this R.M. Malkhani was the state of Maharashtra, has laid down in many of the cases this judgment, and referring to this ratio and these parameters, it has helped the court to come to the conclusion of many of the cases. Now, the status of call recordings around the world globally. Globally, there has been questions about call recordings referring to the thing which we call as consent. Consent would mean in simpler terms that when one person is recording a call, has he obtained a consent of the other person? Has he informed him that his call is being recorded? Is he being aware that his call is being recorded? The things which he is speaking are recorded and would be used later on by the person who is recording such calls. Consent, there are two consents. One is one-way consent, where one of the party to the call recording, when a call is being held between two people, one of the party has consented that the call is being recorded, and he knows that his call would be used on a later stage for anything. And also there is other thing which we say two-way consent, where the consent of both the parties is required. On similar lines, in the country of Australia, the Section 7 of the Telecommunications Interception and Accession Act 1979. The Section 7 prohibits the interception of call between any two people or three people. Section 7 prohibits the interception of a call between the parties to the call, but similar to the Indian Telegraph Act Section 5, there are also exceptions in the law in Australia where the court has allowed the recording of the call, being in the exceptions which have been laid down by its law. But comparing to the Indian law, the Australian law emphasizes more on the part of consent, which is lacking in the Indian law. Similarly, in the state of US, there are questions between the consent, which is either a one party consent or two party consent. A majority of the states in US has a one party consent, where even if either party to the call is consented that his call is being recorded, then the court has legally allowed such recordings. But there are 12 states where specifically it has been stated by court and by law that a two-party consent is very much required for recording of a phone call. And this thing also applies when a third party to the call is recording or hearing or intercepting the calls in one party state, in one consent states. A third party can hear or listen to the calls between two people only with the help or only with the consent of a single party. But the hurdle comes in the 12 states where the court has specifically denied that one party consent is not enough. Two party consent is very much required for hearing or intercepting of a call or recording of a call. It was held in the case of Rathbun versus the United States of America, where a party cannot impose secrecy merely because they are having a call over a mobile phone or having a conversation over a call, where if the one party has consented, the call is being recorded and such recording is being produced before the court has very much allowed such recordings and accepted its legality. In the state of Canada, the Personal Information Protection and Electronics Documents Act, which lays down that the method how a call should be recorded, or simpler terms, how a procedure or what would be the procedure for recording of a phone call, either automatically or via a customs service agent. Often in India now, with the new advancement in the technology, currently there are the new mobile phones which are coming with a technology that if a person starts a recording, immediately it is notified to the other side that his call is being recorded. So this notification helps to overcome the scenario where people are not aware that their phone is being recorded. In the New Zealand, there are no specific laws which say that a call recording is not allowed or is not legally valid, but Part 9A of the Crimes Act in the year 1961, which says that a call intercepted can be done by two ways, either when the conversation is taking place or when the call is in transit. Transition would mean that when a person starts speaking over a call to the other side. In the country of Sweden, which prohibits call recording, stating it to be invalid or illegal, the Swedish Criminal Code deals with the Swedish Criminal Codes deals with the call recordings and the electronic evidence, which is a call recording part of. But the Sweden codes, under the Swedish Criminal Code, the Sweden codes allows call recordings when the court specifically grants the permission to legally record a call. Otherwise, in Sweden, call recordings are illegal and the person who would record a call is often punished by the courts. In conclusion, I would like to say that this feature, which we say as call recording, is not a bad feature or something which would harm the society, but people should use it very wisely. And it is suggested that when we record a call, we should inform the person whose call is being recorded, so he is not on the backdrop that he is speaking, his call is not being recorded, and he would speak something which would harm him in any of the ways. Since the Indian laws are lacking in some feature having specific laws related to call recording, there should be development in the laws in this area, like it is in the US, where specifically the court and the law states that consent of one party, or in some specific states where consent of two parties is required. Even Indian laws should bring consent as an important part or integral feature of such call recordings. Like there are developments where a call which is being recorded is being notified to the other party. More such features should be added to the mobile phones, and even on the legal perspective, more such laws should be brought in by the Indian laws. Thank you.
Janak, thank you very much. It was a very enlightening thing because you had spoken not only about the Indian laws regarding the call recording, but you also spoke about the US laws, Swedish laws, Canada laws. Because as you rightly said, there is a requirement that our laws should also change. So thank you for this excellent lecture, and this is a small token from us to you.